Welcome to the fourth episode of the Binary Agora. In this series, we dive deep into the world of legal tech, breaking down its challenges, its innovations, and the real world impact of top researchers. Today, I will be addressing my latest working paper navigating the interplay between the scaling of LLMs through training data in the generative AI context with the regulation introduced upon gatekeepers through the European Digital Markets Act. When thinking about AI, alarms go off in our heads when we are talking about the risks. But sometimes we do not really know how well they fare against economic evidence or the practical reality of the functioning of these LLMs. Uncovering and applying deep learning architectures, those are transformers, into existing and new technologies ignited this artificial intelligence boom since 2017. AI technologies and also applications progressively became the technology of our time. In particular, generative AI adoption by companies and the major digital players ramped up during the last couple of years and streamlined the use of AI across different sectors. At this point, many scholars have voiced their concerns in terms of the risks that AI poses for fundamental rights at large, especially relating to the rights of the protection of personal data and to privacy. As a matter of fact, in the particular case of training data and what data is inputted into the training and the fine-tuning stages of AI models, we cannot really assert that that their deployment and their development entails a direct breach of data protection and privacy laws and principles, because simply we do not know and we do not have enough knowledge to try to determine what data sets go into those LLMs. Nonetheless, training data and the way in which they can be extracted from the internet has posed several challenges from the economic but also from the legal perspective. For instance, data protection regulators are considering how AI training data reconciles with privacy laws or with cybersecurity requirements. Similarly, the origin of training data has also been put into question, especially when it conflicts with IP and also copyright rules, as we now know from renowned cases such as NY Times v. OpenAI in the US. And finally, the legal support surrounding AI training data is also rounded up by risk regulation, such as the AI Act, which includes a few transparency requirements imposed upon AI deployers. From the practical viewpoint, training data originates in two types of processes involved in an LLM's development and deployment. First, large datasets are inputted into the pre-training and the fine-tuning phases of the development. And second, the LLM also feeds off the data inputted by users via their prompts and also via their reactions to the answers displayed by the LLM. And although AI deployers collect training data via consensual extraction and also via data sharing, billions of tokens built into popular LLMs derive from web scraping. Scraping refers to the retrieval of content available online through automated tools. Normally, scraping takes place over publicly accessible websites, including, for instance, social media profiles. Technically, paywalled websites can also be subject to scraping. And as a matter of fact, most AI deployers now use Common Crawl, that is the largest freely available connection of scraped data with more than 9.5 petabytes of data ranging from 2008 as a data baseline for training their models on a variety of filtered versions from it. On the other side, large-scale artificial intelligence open network, that is Lion, also operates as a database of copyrighted images to try to develop multimodal generative AI. On top of that, inference attack methods have also been applied to existing LLMs and demonstrated that they trained on paywalled websites copyrighted content, and books, also scraped from the web. Preliminarily, we can therefore establish that if training data is mainly based on scraped data, some personal data may also be contained in those unstructured data sets used for training the AI model. For example, Meta recently disclosed its intention to try to exploit its social networks to train its AI systems, including posts, photos, and also content uploaded by users. In this sense, the embedding of scraped data into LLMs at both the pre-training and the fine-tuning stages brings risks meriting regulatory scrutiny on two different fronts. First, the impacts caused to the rights to privacy and the protection of personal data by scraping and processing personal data as a means to power LLMs. Users' expectations over the protection of their personal data, even if they have published bits and pieces of it online, do not align with an indiscriminate scraping of the web happening without their prior knowledge. And given that users are not given a chance to consent to the scraping of their data, it is also at odds with the functioning of notice and consent mechanisms implemented by privacy regulation. And additionally, the scraping of unprecedented volumes of online data entails direct and material harm to consumers, since LLMs face a risk of memorizing their data when they are inputted for training and fine tuning, and then they can leak their context exactly upon a user prompt. On the right hand of the slide, I have listed some of the immaterial and material harms that personal data embedded in AI models may also provoke in terms of the data protection framework. In trying to cope with all of these challenges, the European EDPB decided to classify AI models into two distinct groups. First, those which could be classified as anonymous because they are not designed to provide training data, so that the likelihood of data extraction upon their deployment is insignificant. And second, those which cannot be classified as anonymous under the data protection parameters. Those lying within the first group do not face the imposition of the legal requirements under data protection regulations, whereas those which cannot be classified as anonymous remain captured by these frameworks. For those cases where AI deployers do not surpass the anonymity threshold, the GDPR and other regulations compel data controllers to process personal data based on a legal basis, in this case, Article 6.1 of the GDPR. Other protection frameworks also require such justification in other jurisdictions, such as in China or in Canada. From the long list of legal bases, data protection authorities have proposed two of them as the most feasible alternative to try to justify the processing of personal data in this context. On one side, an affirmative and a specific action by the data subject, that is, consent, could justify such activities. Managing consent in third-party contexts, such as those scenarios arising from scraping content on social media, is not feasible in practice due to the enormous volume of data processed and also their diverse origins. For instance, OpenAI did not even contemplate to include consent as a valid legal basis to try to process data because it was practically impossible to try to obtain consent from every data subject whose personal data might be scraped. This option, therefore, seems to be barred from being used by AI deployers in this context. On the other hand, most AI deployers demonstrate that they process their data and their personal data on their models based on their legitimate interests. Those legitimate interests designate the broader impacts and benefits the controller or a third party enjoys when engaging in the processing of personal data. In this case, the AI deploys capacity to try to extract value from publicly and readily available information online. OpenAI's ChatGPT, Meta's Llama, or Alphabet's Gemini justify the processing of their personal data in this particular fashion. However, the legal venues grow slimmer for some economic operators captured by the DMA. The regulation applies to 7 designated economic operators that have been designated by the European Commission: Alphabet, Apple, Amazon, ByteDance, Booking.com, Meta, and Microsoft. Thus, only these participants in the market will be subject to the limitations spelled out for AI deployers. Building on the experience of cases surrounding Meta's processing activities, the DMA introduces the prohibition embedded in Article 5.2 of the DMA. The provision compels the economic agents designated by the European Commission not to process, combine, or cross-use personal data from their services into their other services, either first party or third party. In particular, processing of personal data using services of third parties is only barred for those cases where it is performed to provide online advertising services. By imposing, therefore, this prohibition, the DMA seeks to end with the barriers to entry placed by the data accumulation capacity of these incumbent digital platforms. The regulation exempts the prohibition in those cases where the end users consent by the processing and also the combination of personal data consent to those activities. And on top of that, Article 5.2 also provides an additional caveat to the whole prohibition. The conduct, so the prohibition, is also without prejudice to the gatekeeper processing personal data, relying on the legal basis set out in Article 6.1 of the GDPR. However, the DMA explicitly details that gatekeepers cannot rely on the legitimate interest legal basis. If we apply the prohibition without bearing in mind the wider interplay with the legal basis of consent and legitimate interest, the result would be as shown now on the slide. For instance, Google's innovations in developing and implementing AI overviews to its Google search functionality, powered by its foundation model Gemini, would be barred from combining and cross-using personal data with the rest of its services, namely its ad services, YouTube, or Chrome. And in a similar vein, ByteDance's proprietary foundation model Seed Thinking, to the extent that it may be incorporated into its CPS TikTok, would have no access to its data generated in first-party contexts, such as TikTok ads, News Republic, or Hello services, even if some of them are only available in other jurisdictions different from the EU. And within the slide, you have also some more examples of the concerned gatekeepers and also the potential implications and impacts of the application of Article 5.2 of the DMA. And as if such a consequence was not dire enough, the DMA complicates the issue even more. Recital 36 establishes that it excludes the legitimate interest legal basis for the processing of personal data. The first question, therefore, that comes to mind is whether the exclusion of the legitimate interest legal basis comprises all types of processing of personal data for gatekeepers as a whole, and also how the legal basis interplays with the gatekeeper's collection of consent for exempting the prohibition. In my own mind, there are two alternative readings that one can draw out from Article 5.2 of the DMA. First one points to the fact that consent is the one and only legal basis for exempting the gatekeeper's prohibition of combining and cross-using personal data across services. In the absence, therefore, of consent, gatekeepers will only be capable of processing personal data based on the rest of the legal basis listed under the DMA, therefore not including legitimate interest, but only outside from the prohibition's scope of application. And in turn, the second scenario presents an alternative view. Consent should be interpreted as the preferable legal basis for the gatekeeper to try to seek the prohibition's exemption, but if consent is not feasible, then other legal bases are readily available to exempt the prohibition, again, not including legitimate interest. So, on one hand, the combinations and the cross-use of personal data across CPSs can only take place upon the condition of consent. So such processing is not feasible in the context of AI training data. On the other hand, those same processing activities may take place either via consent or via further justification under the GDPR. And still, in the context of AI training data, this second scenario results in the fact that the gatekeepers cannot really exempt the prohibition by justifying the value that they generate in the market by catering these AI services. And if we take a step further, recital 36 seems even more complex to try to apply in the AI context. Aside from the fact that consent vis-à-vis the rest of the available legal bases may operate as exclusive or subsidiary conditions to exempting the prohibition, there is a broader impact with the provision and its interplay with LLM training and fine-tuning. As you'll remember, Recital 36 highlights that the prohibition applies without prejudice to the gatekeeper's capacity to process personal data based on the legal basis under Article 6.1 of the GDPR, except the gatekeeper's legitimate interest. The interpretation, therefore, of the clause processing personal data plays a significant role in trying to narrow down further the possibilities of gatekeepers of joining or carrying on within this AI race. The first possibility is that processing of personal data is understood to be equivalent to the concept under Article 4.2 of the GDPR. By this token, gatekeepers would be barred from processing personal data based on the legitimate interest legal basis for all of their processing activities, not only those concerning the prohibition's scope of application. LLM development and deployment would be therefore completely out of the question for any designated gatekeeper. The second interpretation to be drawn out is that of understanding that this processing of personal data refers back to those scenarios where the prohibition does not apply. That is, all other processing activities performed by the gatekeepers within their CPSs and their services. The narrowing down of the GDPR legal basis entails, therefore, that the gatekeepers cannot process personal data within the CPS context with all of the available legal bases under the data protection framework. And finally, the most inconsequential, bearing in mind the stakes of the game, possibility would be to interpret processing of personal data in the sense of Article 5.2a of the DMA. The limitation of this legal basis would only touch upon the processing of personal data for the purposes of delivering advertising, and as such, not all of their processing activities would remain restrictive in principle by the DMA. Before all of these challenges, there are some potential also solutions to try to address this challenging interplay between the training of AI foundation models and the DMA. In practice, AI deployers categorized as regulated targets under the DMA would have no real possibilities of developing their own foundation models and applying them to downstream applications in the EU, as they do in other jurisdictions. In turn, the option open to them would be to outsource their generative AI reliant functionalities. If they are not in charge of the AI model and therefore of its decision making, and therefore cannot be categorized as data controllers in the sense of the GDPR, then Article 5.2 of the DMA would have no bearing over them. Apple's choice to integrate OpenAI's ChatGPT and Alphabet's Gemini into its Apple Intelligence feature on its operating systems, iOS and iPadOS, is also a good example of such a detachment from a liability. By far, this would be the most harrowing consequence of the DMA's application on generative AI models developed abroad. And alternatively, AI deployers could also simply exclude every single EA user from any kind of processing surrounding the model, be that in training, in fine-tuning, or in deployment, which would also complicate development, but would also de facto remove the effects of the prohibition. As a matter of fact, Microsoft's compliant report relating to the integration of LLMs into its LinkedIn functionality remarked that it did just that to try to dodge the tension between these two fields of action. And in the same sense, gatekeepers could also start by siloing their approach to developing and to deploying LLMs by taking into account CPS categories and artificial essentially segmenting the training data and the unstructured data sets necessary for pre-training and also for fine-tuning. All of these potential solutions, however, entail that an inverse Brussels effect takes place to the extent that EA-based outputs in AI models would run scarce and the gatekeeper incentives to integrate AI-reliant functionalities would diminish substantially. In any case, the tension I explored throughout the video demonstrates the need for guidance and cooperation coming from the European Commission towards DPAs to try to square this circle of gatekeeper development and deployment of AI technologies and functionalities. And that's a wrap for this episode of the Binary Agora. If you'd like to learn more about the topic, check out my working paper, which is also included in the description below. And if you have any thoughts or feedback, drop a comment below.